And you'll need to email the attachment today to the clerk. It has to be here today. Yes, got it. Yes, ma'am. Thank you. All right, so you're Travis Smith? Okay, thank you. And so I'm going to take judicial notice of the court's file. And Mr. Smith was previously found not competent to stand trial, was sent to the John Dunn Behavioral Science Center for competency restoration. I've received the report back from that facility. There is the forensic psychiatry report prepared by Dr. Select, dated May 13th of 2026, with the finding that Mr. Smith is currently competent to stand trial. In addition to that, there's a trial competency evaluation report prepared by Dr. Guzman, also with the opinion that Mr. Smith has regained competency to stand trial. Is there any other evidence with regard to competency?
Not at this time, Your Honor. I've got the report.
All right, then at this time, I am going to find Mr. Smith competent to stand trial. Will he waive the formal reading of the indictment?
We'll waive, John.
Mr. Smith, in cause number 25 BCCR 1251, you're charged with the state jail felony offense of theft with previous theft convictions from August 14th of 2025. The indictment alleges you were previously convicted of theft July 29th of 2014, and then after that, December 16th of 2014. And how do you plead to that charge? And are those prior convictions true? Are the prior convictions true?
Yeah.
And did you enter your plea of guilty and true freely and voluntarily? And did you plead guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Adams?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached.
2 years probative fine with $1,000 fine, Judge.
Okay, y'all filled out the 2 years state jail and 2 years county jail.
Yeah,
State-
I couldn't erase it I was gonna erase the county jail. I'm not sure which is
Okay.
but
All right, so it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $1,000 fine to follow all of the rules and conditions of probation, including being on the mental health caseload. So we'll give you everything you need in order to be successful. Is that your understanding?
Yeah.
Do you also, and it looks like also that the state's going to dismiss a misdemeanor harassment charge in cause number 25 CCCR 1, is that a 1 or a 7?
it's 1688.
Thank you. 1688. Your understanding that's going to be dismissed. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Mr. Smith, I'm going to find again that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and that you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. Do I need a pre-sentence report? Is there?
Please, Judge.
Okay.
I think with
So-
the mental health issues.
Yeah, he's gonna have some special issues.
Sure. So I'm going to reset. I'm going to reset your case so that the probation department can do a pre-sentence report. That'll just give me more information about you, your case, your history, what all you might need while you're on probation, and then we'll come back later for sentencing. Okay. All right. We'll see y'all at sentencing. So are you Terrence Alexander? And will your client waive the formal reading of the indictment?
You will, Your Honor.
We're going on count 1 only. Mr. Alexander, in cause number 22-40966, the state has elected to proceed on count one only. It alleges that you committed the state jail felony offense of criminal mischief from July 21st of 2022. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand that? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Alexander is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent. You understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of criminal mischief. Sentence you in accordance with that agreement that you made to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You go back with the bailiff.
Can I get a paper that shows like my back time?
They're going to have to figure that out after court, and it'll be in your judgment and sent over to the jail probably this afternoon or tomorrow.
You know, get all your credit. I've already.
I just said you get all your credit that you're legally entitled to. All right, thank you. Good morning, sir. Are you Victor Perez?
Yes, ma'am.
And Mr. Parker, will your client waive a formal reading of the motion?
Here we go.
Mr. Perez, in cause number 17-26788, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 8th of 2018 for the third-degree felony offense of assault on a public servant. And that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
This motion alleges that you violated your probation in count 1 by committing the new offense of driving while intoxicated November 22nd, 2025 in Hidalgo County, Texas. And is that true or not true?
True.
And then the state's going to abandon 2, correct?
Yes, Your Honor.
Count 3 alleges that you were at a location other than your residence November 22nd of 2025 at approximately 2:08 a.m. And is that true or not true?
True.
Count 4 alleges that you failed to report for the administrative hearing on October 6th of 2025. And is that true or not true?
True.
Count 5 alleges that you failed to report by mail or online to the Jefferson County Probation Department for February, March, May, June, August, September, October, November, and December of 2022, January through December of 2023, January, March, June, July, August, September, October, and December of 2024, and then January through December of 2025. And is that true or not true?
True.
We can drop their many counts.
All right, sir, did you enter your pleas of true to counts 1, 3, 4, and 5 freely and voluntarily? And did you plead true to those counts because they're actually true?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes.
Do you fully understand that?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Perez is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of the lesser offense of the third-degree felony assault on a public servant. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Good morning. Are you Caleb LaFleur?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
So this is the one, so it's not a first.
No, we amended the indictment to third degree.
I didn't write that at the top for some reason, but I see I wrote it in. All right, Mr. LaFleur, in cause number 26 DCCR 0039, you're charged with a third degree felony offense of theft of property. And that is from December 14th of 2025. And how do you plead to that charge?
From December 14th?
November, did I say December?
Yeah,
Sorry, November 14th of 2025.
yes, ma'am.
Are you guilty or not guilty?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
Ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. LaFleur is not
No,
competent?
Your Honor.
Everything changes the moment the word murder enters the courtroom. Up until now, we've mostly seen plea agreements and negotiated outcomes. But this case raises the stakes dramatically. Michael Victoria isn't just facing murder charges. Prosecutors are alleging prior violent felony convictions that could classify him as a habitual offender. That means if he loses at trial, the minimum punishment could start at 25 years and stretch all the way to life in prison. And here's the critical moment. The prosecution already offered 35 years concurrent. The judge makes absolutely sure he understands the risk before rejecting that deal. This is one of the biggest gambles defendants can make in criminal court. Some people believe taking a plea is admitting defeat. Others believe trial is worth the risk when your freedom is on the line. But after today, the judge makes one thing crystal clear: that offer may never come back.
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third degree felony offense of theft of property. Sentence you in accordance with that agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Oh,
Your Honor, if I may, one moment. Mr. LaFleur has provided a unsworn statement taking full responsibility for this event. He does have a co-defendant who he is apparently exonerating of any responsibility, but since it's unsworn, may I ask him to review and let us know if this is in fact his statement while he's on the record?
Sure.
that's
Thank
what
you.
I'm asking.
Thank
Yes, it is.
Okay.
Everything that's on the thing is everything that happened. You want me to read the statement or?
No, sir. As long as you're just letting us know you're under oath right now, that
Yes.
that is your statement, and
That's
that,
my statement.
and everything in there true and correct.
Everything's in there and true and correct.
Okay.
you, Your Honor.
Thank you, Ms. French. Thank you, sir.
Thank you.
Sir, you're Michael Victoria.
Yes, ma'am.
This is cause numbers 21-36410 and 21-36411. Mr. Victoria is charged with murder in each of those cases. And what is the announcement?
We have filled out a plea bargain rejection form, in each of these cases.
All right, give me just a second. So what that means, Mr. Victoria, in each of your cases is that if you go to trial and you're found guilty, the range of punishment. I'm sorry, it's going slow.
It's habitual.
So your indictment alleges, in each of those cases, in addition to the charge of murder, it alleges that you were previously convicted of aggravated robbery, burglary of a habitation, retaliation, and another burglary of a habitation, and an aggravated robbery. All those are from the same date.
There's also a federal conviction.
I'm sorry, can you read?
So a federal conviction, he is habitual.
Okay. And so in your indictment, it alleges that you were previously convicted of all of those prior felonies. In addition, it sounds like there is a federal conviction that was after that, which would make you, for punishment purposes, if you're found guilty and those prior convictions are true, a habitual offender with a minimum punishment of 25 years if you're found guilty, up to 99 years or life in prison in each of those cases. Do you understand?
Yes, ma'am.
And in each of those cases, I have here on the tablet some documents that you've signed with Mr. Eckhart that show that the district attorney's office has made offers in your cases if you wanted to enter pleas of guilty for 35-year terms in each of those cases that would run concurrently, which means together at the same time. You have every right to reject that and have your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are. Do you understand all that?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
Right. And is there any reason to believe that there would be a change or in that offer? Anything that you guys are waiting on evidence or discovery wise?
There's going to be some things that I'm going to ask Philip to request, but nothing that I think we're waiting on. Just it's not in the file, but we're working on it.
Okay. I just want to make sure when we get to that trial date, obviously, the age of this case is very concerning. So I want to, once it's on the trial docket, it's going to be expected to move pretty quickly. So if y'all need anything, make sure you make those requests quickly so that when it gets to trial, we'll get that taken care of. Also want to make sure you understand, sir, that after today, I will not accept this plea agreement. If anything changes, something comes up, the attorneys don't know now, then maybe that would be different. But otherwise, it's going to be a trial, or if you change your mind, you can enter an open plea or to something different. You understand?
Yes, ma'am.
All right, you can go back with the bailiff. We'll get it in the trial docket.
Thank
Thank you, Judge.
Yes, sir.
And so I called out, help, help. And the deputies go, what do you need? I went, help. They opened the door and,
Oh, my God.
oh,
I'm glad you're okay.
yeah.
Good morning. Are you Brian McQuaid?
Yes, ma'am.
And this is 26 DCCR 0402. Mr. McQuaid is charged with aggravated assault with a deadly weapon. And what is the announcement?
Your Honor, he's rejecting the offer of 10 years, probated for 10 years.
Did you do a plea bargain rejection?
Yeah.
Oh, can you do it on the tablet? Where'd you find that? Yeah.
I didn't know there'd be a test.
I'm sorry. I didn't know we had still paper stuff out there. We should. It's on the tablet. Can you do it on the tablet real
Sure.
quick? Thank you. I'll take care of it as soon as y'all do that. Good morning. You're Ava Musgrove.
Yes, Sean.
And this is 25 DCCR 0048. Ms. Musgrove's case is set for trial to begin with jury selection next Monday. And what is the announcement?
So, Your Honor, I have become aware of some medical records that I am needing to request that pertain to Ms. Musgrove.
This hearing perfectly shows how unpredictable criminal court can be. In a single docket, we saw competency restoration, probation revocations, felony theft convictions, rejected plea deals, and murder charges carrying life-altering consequences. Some defendants accepted negotiated agreements hoping for reduced punishment, while others rolled the dice on trial despite massive sentencing exposure. The judge repeatedly emphasized responsibility, legal consequences, and the importance of understanding exactly what's at stake before making these decisions. And that's what makes courtroom proceedings so compelling. Every answer, every plea, and every rejection can completely change someone's future in a matter of seconds. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and real courtroom drama every single week.
That's great.
Okay.
And,
Why
without
just
knowing,
now?
well, because I wasn't aware of them until I received a report.
Okay,
And I just have to be kind of careful
sure.
about,
Did y'all file a motion for continuance?
no, ma'am, we did not, and I apologize.
Mr. Nichols?
State's ready on to understand whatever concerns Mr. Rosen may have.
So old. So what I'll do is reset it to the next trial docket. Whatever needs to take place has to take place before that. There won't be another reset.
Yes, ma'am.
Okay, thank you.
Thank you.
You can go back with the baby.